And now, MaineWebNews.
Room 208 in the Cross Building at the state capitol was filled to capacity today with people interested in a hearing on Governor LePage's regulatory reform proposals. Here are some of the highlights from today's hearing.
It's quite common with a bill that comes before the legislature. Everybody thinks it's a good idea, but when you see the actual cost of putting that proposal into place, you see that it's maybe not quite as high priority as it looked like at the beginning. And this is intended to put a similar process in place for legislation. And it's also important to note that nothing in this provision would keep rules from being adopted even if they have an impact on jobs or fiscal impact. This would simply identify the impacts and allow the people who are considering adopting the rules to have to struggle with those impacts. If at the end of the day it's decided that those costs are worthwhile because the rule is so important, the rule can go forward. So it's important to keep that in mind, that this is just intended to put a focus on those costs, not to keep things going forward if there's a cost.
Our recommendations seek to reduce certain redundancies in our laws, improve the permitting process, improve our enforcement process, and do so in a manner which continues to provide strong protection of our environment and natural resources. Our recommendations include updating certain laws which were originally enacted nearly 40 years ago. Improvements, efficiencies, and streamlining will work to ensure our natural resources remain protected while the department maintains laws and regulations which are clear and concise for all to understand. I strongly believe that our economy depends on our natural resources, and those who try to argue away this versus that approach disregard Maine's strong relationship between its economy and its environment.
I really wanted to be on this committee because I wanted a lot of business regulations, not necessarily just environmental regulations, to come before the committee. So I would hope that the governor might issue something to this committee to let us know what may be forthcoming in the next 2 or 3 weeks.
Obviously the process that the committee decides to use is up to the committee, and the administration would certainly be cooperative in whatever process you decide to use going forward. I think the nature of having a public hearing on a concept draft kind of creates this kind of situation where people are going to come forward with suggested language. I have to say many times I have been before committees where because of concerns that were expressed before a public hearing, a sponsor has come forward with a whole new rewrite of the bill at the public hearing and then has addressed comments to the committee based on the new draft. I know the committee that you sat on, Veterans and Legal Affairs, I experienced that many times where people had heard constitutional questions about issues, and all of a sudden the folks who showed up at the public hearing were faced with a whole new proposal they had to react to. So I think some of this is just sort of the nature of the legislative process.
Okay, well, I'm just going to say that fleshing it out after we vote on this, to me, is not acceptable.
I understand. I think it'll be a while before these proposals are voted on, and there will be a great opportunity for us to have many discussions between now and that time, Representative.
Anxiously wait.
So documents that we have that are in custody of the governor's office and have been used by the governor's office in developing this or any legislation are public documents and can be provided.
Other changes we are proposing include requiring notices of violation be issued within 30 days of discovery rather than being issued months, even years, after the fact, and a minor change to the department's civil penalty section regarding the amount of a minimum penalty.
The notice of violations within 30 days. You find a puddle of bad stuff, but you don't know who done it. It's now the 29th day, and you're under pressure to get out an NOV without real certainty as to whether one is deserved and who should go to. How do you handle it?
Well, I must tell you, I've been on the job for a week. So I'm going to have to rely on my staff to give me some guidance in that area. But I think
rushing.
Well, no, I think the intent here is to make sure that we're not spreading these notifications out over months or even years.
The kids safe products. A lot of people have been worried that that's going to be banned by the governor. That is not in the
That's not part of this amendment.
The repeal of the BPA law right now.
That's not part of this amendment.
The vernal pools.
That's not part of this amendment.
Air regulation changes.
Same, not part.
LERC and how the UT might be managed as far as development.
Yeah, none of that is included in this amendment, Senator.
Pesticide control board.
I'm sorry?
Pesticide control board.
No, not
That's when I
included.
had product stewardship.
It's not included in this
So
amendment.
I'm assuming that right now, those will be handled by the community jurisdiction.
That's correct.
Thank you.
Is the governor backing away from supporting any of those specific proposals, or simply continuing to support them, except that now they're going to be appearing in separate pieces of legislation, not in LD1?
I can't speak for the governor, Representative Treat. I can say that I believe that he's not backing away from these particular issues and these particular points that you bring up, and I do believe that they will be showing up in future legislation, either out of the governor's office or individual bills that are going to be presented by individual members of the legislature.
I really see this as a very important part of the bill. Under current Maine law, courts defer to an agency's construction of its own rules and regulations unless a contrary result is plainly compelled. And that's important language. The end result of that is it often means that there's no meaningful judicial review of agency actions. If you read the court cases of agency appeals, for the most part, the courts defer to the agencies. And in some cases, that may be appropriate. But if you talk to people who practice in this area and talk to their clients who have dealt with it, it's often quite frustrating, because agencies are free to ignore considerations like legislative intent unless the statute has been written so specifically that, again, a different result is plainly compelled. So what happens from time to time, agencies can put their own spin on the rules, their own interpretation on a statute to get the result they want.
There seemed to be near universal support for creating the position of a small business advocate. Secretary of State Charlie Summers suggested that it be based out of his office.
The first I'd like to suggest is to create within the Office of the Secretary of State the position of a small business advocate who will assist small businesses when established agency procedures fail to resolve problems or disputes. The duties of the small business advocate would include: 1, to accept and review confidential complaints of improper actions by a regulator against a small business; 2, to recommend a stop action declaration by the Secretary of State; 3, to create a new small business regulatory agency advisory board made up of small businesses and regulating agencies; and 4, monitor and report on agency compliance with the small business protections within the Administrative Procedures Act.
And I just want to remind the committee that none of these regulations were created in a vacuum. All of our regulations were created in a response to a problem. And sometimes when the problems are solved or somewhat mitigated, now that our roadsides are a little freer of bottles, now that our rivers are cleaner, we sometimes forget what the problem used to be.
As I read what you have here, it would direct the department to go back and rewrite its rules relating to that and any other beneficial reuse, and basically dumb them down to the federal standard, allowing that particular use and probably many other kinds of so-called beneficial reuse. Is it your intention to allow that particular use, and what else would you envision specifically could be allowed under this rewrite of the rules?
I think, Representative, that first of all, it's not our intention to dumb down anything. The reuse piece of this amendment deals with looking at reusing these materials rather than simply dumping them as solid waste materials.
Everybody likes clean air and clean water. That's not an issue. In 2006, the DEP in Maine went on a warpath against Maine landowners who own land on or near wet places. This came out of the shorebird law, and it applied to as much as a quarter-mile in from the high tide mark. Then the DEP misinterpreted the language in the law to include wet spots all over Maine. In 2009, the DEP sent letters to all towns asking them to approve updated language in shoreland zoning laws. Many towns simply copied the language into their town warrants and passed it. They are now dismayed at what happened to them. Those towns who actually read this stuff asked for the maps because they hadn't sent any maps. They didn't vote until they got the maps. In our town, the DEP wanted to take 16 miles of shoreline away from productive use by the families that own that land. They got a huge investment in this. We corrected the errors on the map and sent it back to DEP. We also did some research as to where this came from. Audubon's very own legislator in Maine had slipped the language into a bill. Some may remember the famous quote from the president of National Audubon: "We reject the idea of private property."
As you review and consider these proposals in the weeks ahead, please remember above all else that good, objective scientific research may have already been considered in any earlier bill. It's also available for input into new decisions you will make. Please insist that your decisions that revolve around scientific issues are tied closely to the yardstick of best available science information and research.
I have had my own blood analyzed for toxic chemicals because I'm curious. I'm a scientist. I found out that I have 113 chemicals in my blood. Recent studies showed that 99 to 100% of all pregnant women carry many of these chemicals in their bodies. Our babies are born with the chemicals. Now, unless we keep protections in place, with each generation the chemicals are going to be, the chemical loads in our children will be larger. This problem is not going to go away. It doesn't solve things to say it's okay now to put them back into the products. What we do know about the harmful effects of the chemicals does not bode well for our children's health. And my statement is I believe this is a core issue at the heart of democracy. Maine has been a leader in this. I ask you to consider, is it acceptable to allow corporate interest to poison our food web, poison our bodies, poison our children's bodies for profit?
You have before you a law right now that is already able to do a lot to help the small businesses if we work on it, tweak it, and allow it to happen. I'll give you an example in this law. In this law, where it allows us to do certain buildings, we are allowed to do motels, hotels, and occupancies of mercantile with 2 floors or more, or 3,000 square feet or more. In doing that, the law also has a provision in there at the bottom, at the end of the law, that says something to the effect that you need to be able to go through this and do this. That's okay, but we as the Fire Marshal's office retain the right in 30 days to say we will take charge of that project.
All of this is just part of Phase 1 in the Governor's plan to reform regulations. Phases 2 and 3 are still to come. We'll keep you up to date right here at Maine Web News. If you want the best of Maine, national, and world news, updated 3 to 4 times a day, go to www.mainewebnews.com and make it your homepage.